Good afternoon, everybody. My name is Chris Justice, and I'm here again to join you all for another Q&A session of all things employment law related. I myself, as many of you may know, work out of Samfiru Tumarkin's Toronto offices, and I've been a regular fixture on this session or this Q&A for quite a while. So do get your questions in. As always, I'll do my best to answer as many as I can in the time that I have. And as I always do normally, I'll start off today with a little bit of a talking point as far as some of the news that's coming out recently. The first story actually that I was going to bring up today had to do with the big five banks in the country, as well as many top accounting firms across the country, ending their COVID-19 vaccine policies, or at least ending the requirement for their employees to be vaccinated in order to continue working in the physical workspace. So I think as far as things to come, we're going to see this trend likely continue with a lot of companies who previously had COVID vaccine policies in place, either getting rid of those policies or amending those policies in some way as the world sort of opens up more and more going forward. I think this is important because it definitely suggests that there's no law in place requiring vaccinations. And I will say that if you're an employee who was either suspended or terminated for not getting vaccinated in the past, even if there was a policy in place or not, do not assume that you are without any option. So if you're someone who has lost their job by virtue of not getting vaccinated, whether it's now or several months ago, definitely give us a call. There is a very good chance that if you are in this particular situation, that you will be entitled to severance. So don't take your company's word for it if they're telling you that you're not owed any severance for not getting vaccinated. And also, if you're suspended, don't wait around hoping necessarily that your employer will call you back. Again, definitely best to get in touch with us sooner rather than later so that we can properly advise you going forward. Now that these banks and these accounting firms have also ended their vaccine policies or changed them in some ways, a lot of people have been asking, if they've already been terminated, are they able to get their job back? Can they now go back to their employer and ask that they get their job back now that the vaccine is no longer required? And if you're somebody who's been terminated and you're looking potentially to go back to working for the company that you were let go from, there isn't any strict obligation on the company to hire you, but it may be possible for that to happen. It just kind of depends on the circumstances, and all of this is very new. So I would say that if you are someone who's also interested in going back to the workplace, rather than perhaps fighting for a severance package, then again, get in touch with us so that we can make sure in terms of what you communicate to your employer as far as a potential recall is concerned or return to the workplace is concerned, that you're just not doing or saying anything that might jeopardize that. But technically speaking, once you've been let go, it is normally hard to go back. And at that point, your option is just to make sure that you've been provided with a fair and reasonable severance package. So that was kind of the first thing I wanted to talk about today, as far as the changes to those vaccine policies are concerned, and what it may mean going forward for the future of all this. There's another story in the news that's come up recently. This is in the tech sector within America and Canada to some extent. It seems as though there's going to be a number of layoffs, possible compensation freezes or hiring freezes, as well as possible terminations coming down the line. Again, this is particularly in the tech sector. It seems like it's been hit quite hard. And so it won't be a shock if a number of employees within Canada that work in the tech sector are laid off in the near future or are terminated in the near future. So again, if you're somebody who's in this situation, maybe you're in the tech industry or sector and you've already been laid off or let go, definitely want to get in touch with us, because whatever package is being offered to you, if there is any package being offered to you on your way out, there's a very, very high chance that it's not going to be anywhere close to what your potential entitlement is. And if you're someone who's not been let go yet or suspended or laid off and you work in the tech industry, just bear this in mind, that it may be coming. And as soon as you get any kind of an inkling or suggestion that it might happen, it would be beneficial to speak with a lawyer, again, to just kind of protect yourself and make sure that going forward, you're doing and saying all the necessary things to preserve your rights as best possible. Those in the tech industry, or anyone for that matter, that are not terminated but are being told or will be told that their employment is being temporary, or that they're being laid off on a temporary basis, don't also assume that your company has the ability to lay you off, even if it is for temporary, on a temporary basis. A lot of people assume that if your employer doesn't officially terminate your employment, but instead lays you off due to a shortage of work for an undefined period of time, a lot of people actually assume that the employer can get away with this, or that there is an inherent right for the employer to do this. And again, I don't want anyone assuming that they can do this. And by accepting a layoff or by being laid off and letting several weeks or months or even longer pass, you may actually be doing any case you have more harm than good. And you may be seen as having essentially agreed to the layoff the longer time goes on for. So again, temporary layoffs, if you're in that situation, it's better to get advice much sooner rather than later. So I've got a couple other stories in the news that I want to touch on today. But first, I'm just going to get to one question I see here from Saeed on YouTube. And they're asking or stating they've never received severance as they were terminated for cause. Within a week, they got a job with much higher pay. And Saeed's asking, what are my options in getting severance pay because I was with the company for 12 years? So good question. There's a couple things that are sort of a focal point for me here. Number one, you're saying you never received a severance package because they terminated you for cause. So the question is, more specifically, what cause are they alleging they had to terminate? One example would be you're caught stealing from the company, and so they let you go for cause, and they don't give you any severance on the way out. Well, there's a good chance that you may not be entitled to any severance if it's found that you stole from the company. But there are other situations where someone's let go for cause, and it's nowhere close to being anything like theft or anything really resembling misconduct. So just because your employer says they have cause to terminate your employment, there's a good chance they don't have cause and that they actually would owe you severance. So Saeed, that might be one thing you want to check in with us on as far as the specifics around their case for cause, we'll call it. So that's number one, because if they don't have cause, then yes, generally speaking, you are entitled to severance. Now, if you happen to be entitled to severance, the next question is, does this new job that you got affect how much severance your former employer owes you? And the question to that in your particular case is that it will. So if you were essentially let go from work after 12 years, but a week later you found another job, especially a job that is a better paying job, then your severance entitlements, just Saeed, based on your specific circumstances, you would be able to get no more likely than a total of 20 weeks. And I say 20 weeks, I'm assuming that the company you work for is a relatively big company. If it's a smaller company, then the most severance you could realistically get would just be the 8 weeks. So depending on your circumstances, Saeed, your entitlements could range from 8 to as much as 20 weeks. And that's mainly because of the fact that you found a job as early as you did. And this also assumes that the company does not have cause to terminate your employment. And so, Saeed, even though you may have found a job quite quickly, 8 to 20 weeks may actually still be a substantial amount of money for you. So this may be something you want to touch base with us on, just so that you're not necessarily leaving any money on the table. But it's otherwise good that you were able to find a job soon, because you also don't want to necessarily put all your eggs in, the basket of you're going after your former employer for severance. So definitely get in touch with us if you can, and we'll find out if you do have that entitlement as far as the 8 to 20 weeks and what that would translate in terms of dollars and cents. But thank you for your question very much, Said. Got another question from Rachel on YouTube, I believe, and Rachel is saying that she was terminated without cause 2 days before her probationary period was up. She did not receive any severance, and she's asking whether or not she's entitled to any compensation. So this raises a good point about probationary periods, because a lot of people seem to think that if you are let go or terminated within your probationary period, which is usually a few months, that you're therefore not entitled to any severance. And it may actually be the case that you are not entitled to severance, but that will depend on the facts of the case. And that will also depend on whether or not you signed any kind of a contract that talks about there being a probationary period and what the employer is able to do during that probationary period. So anytime you've got a situation where someone's been let go during a probationary period, one of the key documents to look at is the contract, if there is one, the employment agreement, and with a specific focus being on the probationary period section. But if the contract is not a problem or not an issue, in your case, Rachel, then even though you may have worked for an employer for just 1 or 2 or 3 months, you could still potentially be entitled to several months of severance, believe it or not. There are cases of people who've worked at companies just for 30 days who have ended up getting, 6 months, let's say, for example, of severance. So not a lot of people, I think, know that even with such a short amount of time, your severance entitlements can be fairly significant even in those cases. But it'll come back to whether there's a contract and what that says. So Rachel, you'll definitely want to follow up with us as far as your situation is concerned. Again, just kind of in the same situation that Said was in. Just want to make sure that there's no money being left on the table, and that we can confirm exactly what your entitlements are and sort of what your maximum potential might be, even with as little service as you have. But thanks for the question, Rachel. I think it's important to sort of clarify the issues surrounding probationary period clauses. I've got another question in from Sunny on YouTube. Sunny's saying that over the last 2 years, he or she has accumulated and earned about 12 weeks of vacation. Sunny's planning on resigning, and her employer is saying they will only pay Sunny 3 weeks of vacation if they resign, which they say is the minimum requirement by the Employment Standards Act. And Sunny's asking whether or not their employer could do this, or whether or not they're entitled to get paid for the entire 12 weeks. So the first thing, Sunny, I would say is, or the first thing I would ask would be whether or not there is a written sort of vacation policy that's in place. So a lot of companies will have a vacation policy in place that says if you don't use your vacation in a given year, that you're able to use it in the following year or the year after, or you're in some way entitled to payment at a later time instead of taking that vacation. So that's the first point you want to look to is, what is the company's vacation policy? Is it in writing? And does it say anything about what happens to someone's vacation in the event that they were to resign? Generally speaking, most companies will have vacation policies where you'll have a certain allotment of vacation each year. But if you don't use that vacation time, you're not able to carry it over. So in other words, if you get 3 weeks for every year in terms of vacation, but you didn't take any vacation in the first 4 years, it doesn't necessarily mean that they actually have to pay out those 12 weeks. And in fact, a lot of people get confused between the difference of vacation time and vacation pay. So you may have, let's say, 3 weeks of vacation time each year, but you'll also be paid out vacation pay at a rate of 6%. Some companies pay out vacation pay on every paycheck. Other companies pay out vacation pay at the end of the year. Either way, your company has to comply with the requirements under the legislation as far as vacation pay is concerned. And so you should have hopefully received vacation pay every year you've worked. But there still could be a good chance, Sonny, that you will not be able to have the entire 12 weeks carry over unless there's something clearly that's a term of your employment that clearly sets that out. It's not to say that your employer is right, but they can do that potentially. It just comes down to your particular circumstances. So I hope that answers your question. If you do have anything further, Sonny, feel free to give us a call, and I'm sure we'd be happy to have a chat and sort of flesh out your situation in a bit more detail. I've got another question, or maybe it's a follow up from AJ, or a question from AJ on YouTube actually. AJ is asking, after 8 weeks of warning notice, my employer put me on an unpaid leave of absence, effective today, and will be terminating me after 4 weeks if I'm still unvaccinated, even though I have been working from home permanently in the last 6 years. And AJ's got a follow up question. Why would they bother with an unpaid leave of absence instead of an outright termination? Is there any downside to waiting for official termination before fighting for severance? So we'll just back up, AJ, with the first part of your question. So you've been given 8 weeks of notice, or at least you were given 8 weeks of notice, that if you did not get vaccinated, you would be first put on a leave of absence and then terminated 4 weeks later. So first thing is, your employer does not likely have the ability to place you on an unpaid leave of absence just because you chose not to get vaccinated. So that's the starting point. I would argue that they don't have that right. And by virtue of them putting you on an unpaid leave of absence, they have arguably already terminated your employment. Even though they're saying they're going to terminate it 4 weeks from now, the fact that they stop paying you at a certain point of time can definitely constitute a termination at law. And I wouldn't necessarily say it's in your interest to wait until the end of that leave of absence period unless you're going to get vaccinated, because it seems pretty clear that unless you do get vaccinated, your employer is not going to have you come back to work, even if it is to work from home. And AJ, I think that's another important part of your question, or part of your situation, is the fact that you've been working from home permanently for the last 6 years, meaning you've been working from home before the pandemic even started becoming an issue, or even before the onset of the pandemic. So I think there's a really good argument, AJ, that you could make to say, why is it that I need to be vaccinated if I can do my job 100% from home, and if I have been doing my job 100% from home? Because it seems like that was a term of your employment, to work from home. And so if you're doing your job and there's no issue, then I think from a practical standpoint, as I say, there's a good argument to be made that the vaccine is not required in that case. And this is without mentioning anything about whether there's a law that would actually allow the company to do this, which I mentioned at the beginning, that if they put you on an unpaid leave of absence, there's a very good chance that actually they can't do that, and that constitutes a termination for which you're owed severance. So the fact that you've been working from home just, I think, further strengthens or bolsters your case. And I think is all the more reason not to wait for an official termination. I think you should fight for the severance sooner rather than later, and definitely get in touch with our firm so that we can help you every step of the way. So I think that's a good question, AJ, a good situation, because I know a lot of people find themselves in a very similar situation to that. So thank you for your question and follow up. I've got another question in from Carrie on YouTube. Carrie's asking whether or not an employer can withhold her pay or his pay if they are saying they need her or him to sign a new contract to keep working with them. So just so I understand, Carrie, you are working for a company, and your company wants you to sign a new contract for whatever reason, which anytime a company wants someone to sign a contract mid-employment or during their employment, you definitely want to have that reviewed with a lawyer, first of all, because you don't know necessarily what you're signing. You don't know what effect it will have. You may think that, you're working for a company, they give you a piece of paper to sign, you just sign it really without thinking about it, and you go on your way, and there's no real change to your job. But then later on, you find out that there's some specific clause or section in that contract that, like I say, will be detrimental to you down the road. So that's just number one in terms of anytime someone's given something to sign, kind of pause for a minute and get some advice before you do that. But Carrie, your situation goes a little bit further than that, and you're saying that your employer may be trying to withhold pay or stop paying you until you sign this agreement, and that's likely a huge issue potentially because your employer does not have the inherent right to just stop paying you until you sign a new contract. It wasn't something that you signed up to when you started working there. It may have a bunch of language in there that you've never even agreed to or consent to. And so for your employer to potentially make significant changes to your employment and withhold your pay until you agree to those changes, would not only likely trigger a termination for which you would be owed severance, but it would also arguably trigger bad faith damages because it could be the case that your employer is acting in clear bad faith and sort of hanging your pay over your head to induce you or persuade you or convince you or coerce you to sign this contract. So I think there's a lot of issues going on here that do not seem to be great for your employer, to be honest. But what that means is that you'll probably have more options as far as what you want to do next, what your next step is. So that may be a situation, Carrie, you want to get in touch with us on just so that we can, again, flesh it out in a bit more detail and sort of make sure that you're informed, I should say, of all your potential options. But there does seem to be some issues going on there that I think may open up significant rights in your case. But thank you for your question, Carrie. I've got another question from Rocket on YouTube who's asking whether or not they're required to train the replacement if they're let go, or if they can sort of leave voluntarily or refuse to train the replacement. So I understand a lot of people, especially people who are being told they're let go, will take issue with being asked to train their eventual replacement. And there are actually circumstances where being told to train your replacement after also being told that you're being let go, there are situations where you can refuse or at least make an argument that that's not something you signed up to do. But there are also situations where someone is asked to train a replacement, and they are generally required to do that. So, Rocket, in your case, I don't know if you've been let go or if you're just being asked to train somebody and you think you're going to be let go later on. But that may sort of determine what your options are. So without any further information, it's hard for me to say, but I will just generally say that, again, there are situations where you can refuse to train your replacement, and there are situations where you don't necessarily have as much leverage to refuse to do that. And if you do refuse and you're in that situation where you don't have a lot of leverage, and let's say you leave the company or resign, you could be at risk of foregoing potential severance. So you want to be careful, and this doesn't even have to do with this particular case, but anytime somebody is considering quitting or resigning, doesn't matter for what reason, it's always better to talk to a lawyer first before you take that extra step, because you may think you're within your rights to resign. You may think that you're being forced to resign, that you're being sort of pushed out. And you may think that therefore there's no harm in that, and that afterwards you'll talk to a lawyer and you can go after severance. But then lo and behold, you do that, you talk to a lawyer, and the lawyer says there's a real uphill battle in getting you compensation. And now you've effectively quit your job, and it's obviously going to be much harder to go back and kind of reverse that. So this could apply to not wanting to train a replacement. You could be an employee who is working from home and is being asked to go back into the workplace, and you don't want to go back, and you might just refuse or quit on that basis. Again, it doesn't really matter what the reason is before you quit, and especially before you put anything in writing signaling your intention to quit. Definitely get in touch with us so that we can maybe massage the message or give you some other options in terms of what options are available to you. I've got another question in from Simon on YouTube. Simon's asking, can you still go after severance if you've been on an unpaid leave of absence for not being vaccinated and have been called back to work? Yes. So the short answer, Simon, is yes. The question would be, when did you get placed on an unpaid leave, and when did you get called back? So first of all, kind of what time frame are we talking? Because a lot of people, um, they sort of were put on an unpaid leave of absence later last year, as early as maybe September, let's say, and maybe they're now being called back to work. So that's 8 9 months, right there. Even if they are calling you back to work, you could potentially go after the company for that, 6 7 8 9 month, whatever it is, sort of time frame in terms of severance. But it will also depend on some of the circumstances for, maybe why you were put on the unpaid leave of absence, whether you consented to it, whether you've expressed a desire to go back to work, maybe in the event that they change their vaccine policy and no longer require it. So, Simon, as always, it kind of depends. You've sort of mentioned just now 4 months ago is when they put you on an unpaid leave. So I think depending on who you are, I mean, you could be someone who's earning $10,000 a month, and 4 months is therefore a considerable amount of money. So I wouldn't just say that you have no recourse if they do call you back, even if you refuse to go back. Um, After they've called you back, you could still make an argument that when they put you on that leave to begin with, that your employment was essentially terminated at that point. So I think either way, Simon, it could very well make sense for you to get in touch with us just so that we can kind of clarify some of those finer details, and also put a number on, maybe what the 4 months represents. There has been a lot of resistance, in my experience, anyways, in terms of asking companies to pay someone severance after they've been put on an unpaid leave for not getting vaccinated. But there are also other cases that I've been able to settle in a much quicker time frame. So it's kind of touch and go as far as whether your particular case will require, let's say, a lawsuit, or whether you'll be able to resolve without the need for that. But I think the starting point is getting in touch with us and kind of, like I say, fleshing out some of those details. Um, I've got a comment from Bruce. Bruce is asking if I've always wanted to be a lawyer, but due to my last name being Justice, I will say that I haven't always wanted to be a lawyer, Bruce. But me myself, I kind of made the decision to become one, maybe in part because of my name, but also just my general passion for the law. And yeah, it did end up working out perfectly. But I appreciate the comment, Bruce. It's definitely not the first time I've heard it, and I'm sure it won't be the last. But I guess what can I say? It's in my blood. I've got another question from Andrea. Andrea's emailing, asking, or stating rather, that she was terminated in October of 2020, and asking whether it's too late to pursue severance. Andrea is also saying that she found another job in April of this year, so being 2022. General answer to that, Andrea, is no, it's not necessarily too late to pursue severance. So I definitely think you should get in touch with us. Normally, you have 2 years from the day you're terminated to commence a lawsuit against your employer if you want to go after them for wrongful dismissal or some severance. So if you were terminated in October of 2020, ordinarily you would have at least up until October of this year to pursue severance. And the fact that you found a job in April of this year is great for your life and generally speaking, but there's still an ability, I would argue, for you to collect severance from the period of October 2020 all the way to potentially April of this year, or even beyond, depending on what kind of job you have and how much money you're making. So it's not too late, but it will become too late in a relatively short period of time. So you want to get in touch with us ASAP. And again, just to remind everyone, if you're considering going after your company for any kind of action, whether it's you feel like you've been wrongfully dismissed, or you've been harassed or bullied at work, or anything that you deem to be problematic that you're looking for compensation for, just remember that there is that general 2-year time frame for you to commence a lawsuit. And if we're talking about human rights concerns specifically, there's actually, generally speaking, a 1-year time frame. So whether it's human rights related or not. You don't want to wait too long, because even if you have a slam dunk case that's very lucrative or valuable, the fact that you've waited more than a year or waited more than 2 years could mean that you're essentially dead to rights, and you have no option at that point. And so time is definitely of the essence, for sure. That said, that will call it a day for my session today, guys. I appreciate, again, everyone's questions. I'm sorry for those that I didn't get to answer, but we do this very often. You'll see down there, you can join us again live, 4 p.m. Eastern, for another employment law Q&A session, this time with Darren. So if you've got any questions that I couldn't answer today, definitely save them for Darren. I'm sure he'll be happy to answer as many as he can. And until then, I will see you when I'm here up next. But do take care, everyone. Thanks for joining us. Get in touch with us if you have any questions. But until you see you again, do take care. All the best. Bye for now.